So let's just look at the third of the M'Naughton rules. We've looked at defect of reason, we've looked at disease of the mind. The third is the nature and quality of the act. And in this is a very short video, it's very, very simple. There are two options. The first is that the defendant did not know the nature and quality of the act, or the second is that they did not know that what they were doing was wrong. In the cases of those where they did not know the nature and the quality of the act, that could be one of three things. It could be that they did not know what they were doing. It could be that they did not appreciate the consequences of what they were doing. Or thirdly, it could be that they did not appreciate the circumstances in which they were acting. In all of these three instances, it means that there's no mens rea. And as such, they're sufficient for insanity and will get the special verdict, not guilty by reason of insanity. Alternatively, of course, it may mean that the defendant did not know what they were doing was wrong. And in that instance, they have the mens rea, but because of their insanity, they do not know it was wrong. Either way, providing that they are doing this because they have a defect of reason and because they have a disease of the mind, it will mean that they can have the insanity plea. Now, it must be said that the defendant must believe it's legally wrong, not simply that it was morally wrong. And the way to think about that is to look at the case of R.V. Windle. And in R.V. Windle, the defendant killed his insane wife, who was always threatening suicide. He killed her with 100 aspirin. He said, when the police came, "I suppose they will hang me for this," indicating he knew it was legally wrong, whereas he thought it was morally right. So he thinks killing his wife out of probably love, he didn't want to see her suffer, was the morally right thing to do. The fact that when the police arrived he said, "I suppose they will hang me for this," means that he had some idea that what he was doing was legally wrong because it attracted the hanging death penalty. Knowledge that an act is wrong means legally, not morally wrong. Killing terminally ill spouse might be morally justified, but it's a criminal offence. So in effect, Windle was found guilty and the sentence of death was upheld. Of course, when we come on to looking at homicide and murder, there may now be a partial defence of diminished responsibility which could be argued. And just so as you are aware, the case of Windle has been doubted in two other cases. One is R.V. Dean Johnson. That's a 2007 case. And the High Court in R.V. Stapleton, which is an Australian case, which the date for that is again 1952, so the same year, refused to follow Windle. They didn't follow it. But as it stands at the moment, Windle is sort of still the key case law. So that concludes insanity. And we'll go back to the M'Naughton rules just to make sure. We have to prove three things. The first is a defect of reason. The second is a disease of the mind, and those two things must be such so that the defendant does not know the nature and quality of the act or does not know that the act was wrong. I hope you understand insanity a little better after those three videos.